each other. How are you going to fund a buy-sell then? Particularly when what you get is Joe put up the money and Steve put up the sweat equity. Yeah. And so they built a business that's worth a couple of $1 million and Steve gets hacked off because Joe's draining the business. Now, but Steve doesn't have any money to buy Joe out with. Or does he? Well, sometimes you can get some creative financing based on Steve's track record, but sometimes Steve is screwed. When you do this, you got to think about it, because remember, you are representing both parties here. When you're doing a buy-sell, you are representing both parties. Now, it may be two lawyers going back and forth, and trying to negotiate a buy-sell agreement in the first place. I'll be right there. But keep in mind, if you got the guy with the money, okay, fine. But if you got the guy without the money, you better make sure that there's some way for him to get it. Now,
as in a divorce case, using it as an example, do you recommend two attorneys, one representing the interests of each of the parties?
No, actually, my self-interest tells me let one guy do it all. Then he's completely disqualified, and I can make all the money in the world.
Oh, okay.
Now, if you got two different guys doing a deal, you run up the cost at that end, but then there's never a disqualification because you're not in the middle. You only have the one side, but that never happens, because when people start a business, you're working on a shoestring, or you're trying to keep costs down, and hey, it's pretty easy to do a business. I had two people come into me about 4 years ago. They said, we want to merge our two businesses together. Both were moderately successful. And I said, okay, that's fine, but if you do that and you guys have an argument, I can't represent either one of you. Okay, fine, no problem. So they signed the releases like that, and they turned me, and I said, okay, if you want me to do this, here's a list of questions we have to get answered. I think question number 3 or 4 on the list was, if you guys can't agree on something, what are you going to do? How are you going to resolve the issue? Oh, we'll never disagree. I said, oh, really?
From the Book of Solomon.
Yeah. Oh, really? I said, okay. I'm glad to hear that. You agree? Do you both agree that you're never going to disagree? Yeah, of course. Okay. Where do you want your mail sent? Oh, send it to my office. It's over here. Well, what about the mail addressed to her half of the business? Oh, you send that there too. Wait a minute, says she. I want this stuff sent to me. How long did it take before they disagreed? So I said, well, okay. How are you going to, when you have disagreements, who do you want to make the decision? You will. Oh, no, I'm not.
That's when he named Roger.
That's why Roger names me and some stuff too. Yeah. No. Yeah. So, that merger never went past the first 30 minutes. When they walked out of my office, they were screaming at each other about who would be in charge of deciding where the concrete trucks were parked. Okay. So, irreconcilable differences. When you have buy-sells, at least ask them about it. All right, death of an owner. Estate taxes, this is why do one. You guys understand all of this, but let me point out, you want to see a big fight? Have somebody who's money short with a chunk of the company and he can't sell it. You want to, especially if he's got to do it to pay taxes, and particularly when the company is not cash flow short because they're servicing everything and turning out a nice profit, but where the company has got a big value and the tax man cometh. And either you come up with a way to do that, or you allow him to sell to an outsider, or the tax man's going to seize the company, and then you run into court to get a partition, which guts your company's value. Everybody know what partition is? Mm-hmm. Yeah? Everybody? Okay.
No, I don't know what it is.
You don't? All right, that's when the court comes in and says, okay, we're going to divide the company. We're going to do a Solomon, and we're going to cut it up. A lot of times what the court does is they hold a forced sale, and they take the money and divide the money in two.
Is an LLC going to get something called a charging order?
There's all kinds of different ways, but that's certainly one.
There's a Virginia Supreme Court case about 5 years ago in which the Supreme Court said there is no Virginia law, it's just not there, that the court can't invade the LLC.
Court can do anything it wants
We all
to.
think there's charging orders and all that, but the Supreme Court case on a narrow point, I don't think it's good law. They said, no.
It's good law if the Virginia Supreme Court said it.
Well, for them.
And it's good law if you're litigating in Virginia. I will tell you flat out, in Maryland, if they have to seize an estate and sell it off on a partition, in order to pay the tax man, they will do that. Yeah. And of course, there goes your value too, unless you want to buy the other half out, which you may not be able to do. So pay attention to this. God knows how often that comes in. Now, we were talking earlier about disability. Yeah. If you have a smaller business, one where you've got some serious, both sides are putting serious sweat equity in, and somebody gets disabled, you may need to buy them out, or you're going to have to produce the equivalent income or something. You guys are financial planners. David, Riyadh, you other guys. Madam, actually you're an attorney, so you don't get that one. You got to think about this. Guy gets disabled, he owns $1 million business. What's he going to do? Now, if you don't do it, I'm going to get a phone call which goes, oops. And then we start looking at things like partition, bankruptcy court, going into Chapter 11, operating under bankruptcy provisions, and your disabled owner is pulling at everybody's heartstrings. I've been on the wrong side of that one. It really bites. I don't like that at all. And again, we're back to the litigator sell at a depressed price. Irreconcilable differences. Do I need to beat this one to death more than I've already done? No? David, you're sort of nodding your head. You want me to beat on it some more?
No, it just
it
rings too many bells.
Yes. Then you see what the problem is here. And if you can't get out, I get called. You got to have a way. And oh, by the way, if you name in your contract, a so-called decider to sit down. Hey, if we can't agree on what the value of the company is, Roger will come in and tell us what the company is. Right. That's your full employment act, Ed.
Right.
Well. And not only you, but I absolutely guarantee you 2 other guys will be in there too. Because you'll be working for Roger as the decider, and each of the other 2 parties will have their own expert, and the fight is on.
That's true.
And I'll be having a great time. With wonderful cross-examination questions about present value. Rising interest rate, floating interest rate, debentures, bonds. Which way did you calculate it there? Profit flow, accounts receivable, and all of the other fun things. Now here's the problem with that. Everybody here understands all those terms I used, right? Amory, tell the truth.
Lots of accounting terms I don't really understand.
Okay. Other than Emery, playing games.